Customs has released the cargo, the post-clearance audit process begins. The post-clearance audit is the pertinent review of the commercial data, sales contract, financial and non-financial record, physical stock, and other asset of the traders. The goal is to assess and raise traders' compliance. In many ways, with the conformity with the WTO Customs Valuation Agreement, PCA has proven to be the crucial instrument for the effectiveness of the customs procedure. It also aids the implementation of the customs risk management plan, making it simpler for the customs to assess the amount of risk associated by each trader.
CAU1 2019 is also known as Post-Clearance Audit and Prior Disclosure Program. It discussed the post-clearance audit of all records required to be kept by all importers, beneficial or true owners of all imported goods, customs broker, agents, and locators as provided in Section 1003, subsection A, B, and C as a compliance and revenue measure. In line with that, you will also encounter terms that are related to post-clearance audit, such as customs broker, customs clearance, fraud, free zones, locators, misclassification, misdeclaration, negligence, and undervaluation.
Under the requirement to keep records, Section 1000 entitled Audit and Examination of Records in CMTA emphasized the responsibility of the Bureau in conducting audit examination, investigation, inspection, and verification of importation records to assess the correctness of goods declaration within 3 years from the date of final payment of duties and taxes or customs clearance. The criteria for selecting companies to be audited comprises of A. Relative magnitude of customs revenue to be generated from the company. B. Rates of duties of the company's imports. C. Compliance track records of the company. And D. Assessment of the risk to revenue of the company's import activities.
Post-clearance audit is mandated to importers, locators, customs brokers, and all other parties engaged in customs clearance and processing. They are required to keep records at the principal place of business for a period of 3 years. For importers, maintenance of records shall start from the date of final payment of duties and taxes, whichever is latter. For the locators and other parties engaged in customs clearance, shall start from the date of filing of the goods declaration. So, what are the records required to be kept? So, the records that are required to be kept are letter A, documentation of the organization and structure of the company. Letter B, documentation on orders and purchases. Letter C, documentation on shipping, importation, exportation, and transport. Letter D, documentation on manufacturing, stock, and resale. Letter E, financial documents and other accounting information. Letter F, any documents describe the accounting system used by the importer. And lastly, all records or information of the documentation I said earlier is in electronically recorded or restored.
What will happen if you fail to keep records? First, suspension or cancellation of accreditation as importer or broker. Second, surcharge of 20% on dutiable value of the goods which is the subject of the importation for which no records were kept and maintained. Third, whole delivery or release of subsequent imported articles to answer for the fine and any revised assessment. Fourth, criminal prosecution punishable with imprisonment of not less than 3 years and 1 day, but not more than 6 years, and or fine of 1 million pesos, and or lastly, waiver of the right to contest the result of the audit.
The Commissioner must send an audit notification letter to entity designated for the post-clearance audit in order to carry it out. It must be served to the importers personally at the principal place of business, personally at registered mail address, or through electronic mail address for the period of 30 days previous to its expiration.
During audit, full and free access to the premises where records are located shall be given. Failure or refusal to full and free access to authorized customs officer will result to the following penalties: suspension or cancellation of accreditation as an importer or broker, punishment for contempt, for contumacy, or for refusal to provide access from the proper court having criminal jurisdiction over the matter, reassessment of the importations subject of audit, the declared transaction value being presumed inaccurate, applying therein the correct valuation method, tariff classification, quantity, and or country of origin as applicable based on available data. Surcharge of 20% on the dutiable value of the goods which is the subject of the importation for which no records were kept and maintained. Whole delivery or release of subsequent imported articles to answer for the fine and any revised assessment, or criminal prosecution punishable with imprisonment of not less than 3 years and 1 day, but not more than 6 years, and or fine of 1 million pesos.
After the audit is finished, the Bureau of Customs must deliver a copy of the final audit findings to the Department of Finance and the Bureau of Internal Revenue within 30 days of the issuance. Any businesses that have found to have missed paying the proper duties and taxes will be fined. A fine equal to 125% of the revenue loss will be assessed if negligence is proved to have occurred, while simple negligence or inadvertent error will only result in a 25% penalty of the lost revenue. On the other hand, if the defendant is accused of fraud and proven guilty, they will be punished with a fine equal to 6 times the amount of lost revenue and or a sentence of no less than 2 years nor more than 8 years in jail. It is recommended for businesses to think about taking advantage of the prior disclosure program given the severe fines that could be assessed during the post-clearance audit.
So now, let's move to prior disclosure program. The question is, what does prior disclosure program talks about? A prior disclosure program is an option for importers to voluntarily notify the Bureau of Customs of any mistakes or shortcomings in goods declarations. It also allows the Commissioner of Customs to access advanced disclosure of errors and omissions in importers' goods declaration. Who may avail prior disclosure program? Any importer who has not been issued audit notification letter and any importer who has been received audit notification letter provided that the necessary documents are submitted within 90 days from the receipt of audit notification letter. A prior disclosure program application shall not be applicable for goods declaration which is subject to the pending cases with any other customs office. Goods declarations already covered by the filed case and pending in the court, and for all goods declarations involving fraud.
What are the documents required to be accomplished to avail the prior disclosure program? 1. Duly accomplished application form disclosing the errors in the goods declaration. 2. If applicable, tendering payment of the deficiency duties and taxes. Should there be any adjustment of the application, the importer may amend the prior disclosure program within an additional non-extendable period of 30 calendar days from the date of filing of the application.
What will happen if the BDP application has been approved? First, in case of non-receipt of A&L, the applicant shall only pay the deficiency in duties and taxes plus a legal interest of 20% per annum. Second, if the applicant receive an A&L, the applicant shall pay the deficiency in duties and taxes plus a penalty of 10% based on deficiency and a legal interest of 20% per annum. And third, if the applicant disclose and file within 30 days from the payment date, or royalties and other proceeds, any subsequent resale, disposal, or use of importations, directly or indirectly to the seller, shall only pay the deficient duties and taxes without any penalty or interest. However, if the applicant fails to pay within 30 days, the above provisions shall apply.